Counsel, did you both examine the revised?
I did, Judge.
Yes, Your Honor.
You did. Bring it here up, please.
Judge, may I ask one question before?
Yes.
Does the court have a podium or a small table or something to put in front of the jury box?
Well, we normally, that front is big enough to put all the exhibits on.
Yes, sir.
If you don't think that's big enough for you, we can try to find something, but normally we put, that's why when we built the court, we had that kind of wide.
Yes, sir. We'll use that. Thank you, sir.
Okay?
Yes, sir.
Okay. If you think you need something else, just let them know, and we'll see what we do.
Yes, Your Honor.
Okay. Bring it here up. Welcome back from lunch. Had a long lunch, didn't you? All right, call the case, Madam Clerk.
Commonwealth of Virginia versus Stephen Rankin. Is the Commonwealth ready?
Commonwealth ready.
Is the defense ready?
We are, Your Honor.
Defense rest,
Defense is rested, Your Honor.
Commonwealth rest.
Commonwealth ready, Your Honor.
All right, members of the jury, that means there is no more evidence to come before you with respect to this case. Madam Clerk, is the mic on? At this time, it is my duty as judge to give you the law that applies to this case. And I shall do this by way of instructions. Let me advise you that we have 20 instructions. Number 1 is just as important as number 20, vice versa, and all those in between. And each one of you have legal pads, and you have a pen. You need not try to write down anything about these instructions, because at the appropriate time, you will have with you, once you finish your deliberations, all of the instructions along with all of the exhibits which have been admitted into it. You understand this? Okay, Madam Clerk, give us some water, please. Excuse me. Instruction number 1. The defendant is charged with the crime of first-degree murder. The Commonwealth must prove beyond a reasonable doubt each of the following elements of that crime. Number 1, that the defendant killed William Chapman II. And number 2, that the killing was malicious. And number 3, that the killing was willful, deliberate, and premeditated. If you find from the evidence that the Commonwealth can prove beyond a reasonable doubt each of the above elements of the crime is charged, then you should find the defendant guilty of first-degree murder, but you shall not fix his punishment until your verdict has been returned and further evidence has been heard by you. If you find from the evidence that the Commonwealth has proved beyond a reasonable doubt each of the first 2 elements of the offense as charged, but you do not find beyond a reasonable doubt that the killing was willful, deliberate, and premeditated, then you should find the defendant guilty of second-degree murder, but you shall not fix the punishment until your verdict has been returned and further evidence has been heard by you. If you find that the Commonwealth has failed to prove beyond a reasonable doubt that the killing was malicious, but that the Commonwealth has proved beyond a reasonable doubt that the defendant killed William Chapman II, and further, number one, that the killing was the result of an intentional act, and number two, that the killing was committed while in mutual combat or in the sudden heat of passion upon reasonable provocation, then you shall find the defendant guilty of voluntary manslaughter. But you shall not fix the punishment until the verdict has been returned and further evidence has been heard by you. If you find that the Commonwealth has failed to prove beyond a reasonable doubt any of the above offenses, then you shall find the defendant not guilty. Instruction number 2. Malice is that state of mind which results in the intentional doing of a wrongful act to another without legal excuse or justification at a time when the mind of the actor is under the control of reason. Malice may result from any unlawful or unjustifiable motive, including anger, hatred, or revenge. Malice may be inferred from any deliberate, willful, and cruel act against another, however subtle. Heat of passion excludes malice when that heat of passion arises from provocation that reasonably produces an emotional state of mind such as hot blood, rage, anger, resentment, terror, or fear, so as to demonstrate an absence of deliberate design to kill, or to cause one to act on impulse without conscious reflection. Heat of passion must be determined from the circumstances as they appear to defendant, but those circumstances must be such as would have aroused heat of passion in a reasonable person. If a person acts upon reflection or deliberation, or after his passion has cooled, or there has been a reasonable time or opportunity for cooling, then the act is not attributable to heat of passion. Instruction number 3. You may infer malice from the deliberate use of a deadly weapon, unless from all the evidence you have a reasonable doubt as to whether malice existed. A deadly weapon is any object or instrument, not part of the human body, that is likely to cause death or great bodily injury because of the manner and under the circumstances in which it is used. Instruction number 3A. Willful, deliberate, and premeditated means a specific intent to kill, adopted at some time before the killing, but which need not exist for any particular length of time. Instruction number 4. The difference between murder and manslaughter is malice. When malice is present, the killing is murder. When it is absent, the killing can be no more than manslaughter. Instruction number 5. To prove the charge of murder, a Commonwealth does not have to prove a motive for the killing. The presence or absence of a motive may be considered in arriving at your verdict. Instruction number 6. Once the Commonwealth has proved there was an unlawful killing, then you may infer that there was malice and that the act was murder in the second degree, unless from all the evidence you have a reasonable doubt as to whether malice existed. Instruction number 7. You have been instructed on more than one grade of homicide, and if you have a reasonable doubt as to the grade of the offense, then you must resolve that doubt in favor of the defendant and find him guilty of the lesser offense. For example, if you have a reasonable doubt as to whether he is guilty of first-degree murder or second-degree murder, you shall find him guilty of second-degree murder. If you have a reasonable doubt as to whether he is guilty of second-degree murder or manslaughter, you shall find him guilty of voluntary manslaughter. If you have a reasonable doubt as to whether he is guilty at all, you shall find him not guilty. Instruction number 8. The defendant is charged with the crime of using a firearm while committing murder. The Commonwealth must prove beyond a reasonable doubt each of the following elements of that crime. Number 1, that the defendant used a firearm. Oh, hold on, no one is to exit or enter while I'm reading these instructions. That's why the deputy's at the door. I'll start over again. Instruction number 8. The defendant is charged with the crime of using a firearm while committing murder. The Commonwealth must prove beyond a reasonable doubt each of the following elements of that crime. Number 1, that the defendant used a firearm. Number 2, that the use was while committing or attempting to commit murder. If you find from the evidence that the Commonwealth has proved beyond a reasonable doubt each of the above elements of the crime is charged, then you should find the defendant guilty. But you shall not fix his punishment until your verdict has been returned and further evidence has been heard by you. If you find that the Commonwealth has failed to prove beyond a reasonable doubt either or both of the elements of the crime, then you should find the defendant not guilty. Instruction number 9. It is not necessary that each element of the offense be proved by direct evidence, but an element may also be proved by circumstantial evidence. You may convict the defendant on circumstantial evidence alone or on circumstantial evidence combined with other evidence if you believe from all the evidence that the defendant is guilty beyond a reasonable doubt. When the Commonwealth relies upon circumstantial evidence, the circumstances proved must be consistent with guilt and inconsistent with innocence. It is not sufficient that the circumstances proved create a suspicion of guilt, however strong, or even a probability of guilt. The evidence as a whole must exclude every reasonable theory of innocence. Instruction number 10. If you believe that a defendant was without fault in provoking or bringing on the difficulty, and if you further believe that the defendant reasonably feared, under the circumstances as they appear to him, that he was in danger of being killed or that he was in danger of great bodily harm, then the killing was in self-defense, and you shall find the defendant not guilty. Instruction number 11. Self-defense requires proof of a reasonable fear of death or bodily harm based on an honest appraisal of the surrounding circumstances and an act by the victim which is taken by the defendant to signal the intent to inflict death or bodily harm imminently in a proportional response by the defendant. Instruction number 12. The law of self-defense is the law of necessity. A defendant must reasonably fear death or serious bodily harm to himself at the hands of his victim. It is not essential to the right of self-defense that the danger should in fact exist. If it reasonably proves to the defendant that the danger exists, he has the right to defend against it to the same extent and under the same rules as would obtain in case the danger is real. A defendant may always act upon reasonable appearance of danger, and whether the danger is reasonably apparent is always to be determined from the viewpoint of the defendant at the time he acted. Instruction number 13. In determining whether the defendant at the time of the incident was reasonable in his belief that the decedent posed a threat of serious bodily harm, you must evaluate his actions from the perspective of a reasonable defendant on the scene at the time of the incident. In determining the reasonableness of the defendant's belief, you may consider, among other factors, the decedent's actions towards the defendant, the decedent's noncompliance with the defendant's commands, and the decedent's active resistance to arrest. It is not necessary that risk of serious bodily harm be real, only that the defendant at the scene reasonably believed at the time of the incident that such risk exists. If you find that the defendant reasonably believed at the time of the incident that the decedent posed a threat of serious bodily harm to the defendant or the public, then the killing was in self-defense, and you shall find the defendant not guilty. Number 14, a person who really apprehends bodily harm by another is privileged to exercise reasonable force to repel the assault. The privilege to use such force is limited by the equally well-recognized rule that a person shall not, except in extreme cases, endanger human life or do great bodily harm. Moreover, the amount of force used must be reasonable in relation to the harm threatened. Instruction number 15. You must not consider any matter that was rejected or stricken by the court. It is not evidence and should be disregarded. Instruction number 16. The statements presented to you as having been made by the defendant are submitted for your consideration along with all the other evidence. The weight, value, credibility, and reliability of those statements are questions for your determination. Instruction number 17. If you believe from the evidence that a witness previously made a statement inconsistent with his testimony at this trial, the only purpose for which that statement may be considered by you is for its bearing on the witness's credibility. It is not evidence that what the witness previously said is true. Instruction number 18. You are the judges of the facts, the credibility of the witnesses, and the weight of the evidence. You may consider the appearance of the witness and manner of the witnesses on the stand, their intelligence, their opportunity for knowing the truth, and for having observed the things about which they testified, their interest in the outcome of the case, their bias, and if any have been shown their prior inconsistent statements, or whether they have normally testified untruthfully as to any material fact in the case. You may not arbitrarily disregard the legal testimony of a witness. However, after you consider all the evidence in the case, then you may accept or discard all or part of the testimony of a witness as you think proper. You are entitled to use your common sense in judging any testimony. From these things and all the other circumstances of the case, you may determine which witnesses are more believable and weigh the testimony accordingly. Instruction number 19. The fact that a defendant has been indicted by a grand jury is not evidence against him, and you should not consider it. Instruction number 20. The defendant is presumed to be innocent. You should not assume the defendant is guilty because he has been indicted in his own trial. This presumption of innocence remains with the defendant throughout the trial and is enough to require you to find the defendant not guilty unless until the Commonwealth proves each and every element of the crime beyond a reasonable doubt. This does not require proof beyond all possible doubt, nor is the Commonwealth required to disprove every conceivable circumstance of innocence. However, suspicion or probability of guilt is not enough for a conviction. There is no burden on the defendant to produce any evidence. A reasonable doubt is a doubt based on your sound judgment after a full and impartial consideration of all the evidence in the case. Those who want to leave now, you can go to leave.
permission to move about the way. Thank you, sir. Good afternoon, ladies and gentlemen. So we've been together since last week, and I want to again, on behalf of the Commonwealth, thank you so much for your great attention to this matter, a very important case to the Commonwealth, and no doubt the defendant as well. We have gone over quite a bit of things in this case, and as you can see, there's lots of evidence in front of you that you get to consider and that you've observed come into evidence over the course of the past few days. And I want to talk to you a little bit about what I talked to you about in the beginning of this case. We came together and I told you that we were going to go over a lot of things. I told you that you were going to hear a lot of terms. You were going to hear medical, scientific, legal terms. You were going to hear technical terms. You were going to hear all kinds of things. And I'm certain that you are now fully educated on a lot of different things. You know more about anatomy. You know more about tasers. You know about firearms. You know all kinds of things. But I want to draw your attention back to the nature of this charge. Before I even start talking about the way the evidence rolled out before you, I want to go back to what this charge is and what this defendant is charged with doing. He is charged with, on April 22nd of 2015, at 1098 Frederick Boulevard here in the city of Portland, with the willful, deliberate, and premeditated killing of 18-year-old William Chapman. And he is charged with using a firearm in the commission of that murder. Now, you just heard all of the instructions that the court has provided to you about the way you must use the evidence that you saw come into this case to make a determination about this defendant's guilt. One of the things that stood out to me is that you have to think about the reasonableness of any perception of this defendant that he had the right to use deadly force against this young man. Once again, you heard some of the things I said to you last week. One of the things I asked of you was that you not check your common sense at the door. And now you have heard from the court that in judging the credibility of the witnesses and examining all of the evidence in this case, that you are entitled to use your common sense. You have heard information that's come in about distances. You have heard from witnesses who have been as close as I am to you. You have heard from witnesses who have been a football field to a football field and a half away from the incident. You've heard from the defendant. You've heard from several different people, and you are entitled to use your common sense about who saw what from what distance on the date of the offense. You heard from every single eyewitness in this case, and every single eyewitness in this case, with the exception of this defendant, said to you that they could see the victim's hands. They were asked, and they said there was no gun in his hands. There was no knife in his hands. There was no stick in Mr. Chapman's hand. There was nothing in his hand. You heard from the defendant about what he calls tunnel vision. And you heard how he completely blocked out what was going on around him. And today he can't tell you who was around him when we get to the end of this incident, when William Chapman ends up getting shot in the face and the heart. He can't tell you what was going on inside of his tunnel vision with Mr. Chapman's hands. After he testified during his direct examination that hands are the deadliest things. But yet inside his tunnel vision, he can't tell you what was happening with Mr. Chapman's hands. Common sense. This defendant also says that at 6 feet, Mr. Chapman charged him full speed, and he only got 3 feet. Common sense. Reasonable force. That's another thing that you're going to be instructed on. That means if somebody punches me in the face, I have to respond with reasonable force. Unless this person is Shaq, I can't respond with deadly force if somebody's punching me in my face. Common sense. Let's talk about this use of force policy manual. All places of business have policy manuals. My office has a policy manual. The Portsmouth Police Department has a policy manual. McDonald's has a policy manual. This defendant admitted he's worked other places and they've had policy manuals. And this policy manual is in evidence today submitted by the defense. And this policy manual has guidelines. And what the guidelines say is that the officer will only use the force reasonably necessary to protect themselves. And for deadly force, the officer must reasonably expect death or bodily injury. That's what those guidelines say. That's the policy. Reasonable force. And must only reasonably expect serious bodily injury or death to use deadly force. That's the policy. And that policy doesn't even supersede Virginia law. That's in evidence. Let's talk about what else we talked about with respect to this policy and this defendant's knowledge and his training as a Portsmouth police officer. He talked to you about that he got legal training. He talked to you about his familiarity with Virginia law. He said things like resisting arrest. He said things like disarming a police officer. And I inquired about those code sections. And those code sections came out. Resisting arrest. Assault on a law enforcement officer. Disarming police officer. Resisting arrest is Virginia Code Section 18.2-479.1. Assault on a law enforcement officer 18.2-57 subsection C. Disarming a police officer, Virginia Code Section 18.2-308.1. These are enumerated code sections under the Virginia law. That means the Virginia law anticipates that police officers are going to come in contact with people who resist arrest. Police officers are going to come in contact with people who assault them. Police officers are even going to come in contact with people who disarm them. And Virginia law has anticipated that these people will live to face prosecution for violating those Virginia laws. That's what the Virginia Code and the Virginia law anticipates when we talk about people who resist arrest, when we talk about people who assault law enforcement officers, when we talk about people, even though we don't have any evidence in this case that this young man took the gun out of, or took a taser out of this defendant's hand. He didn't take anything out of this defendant's hand. We don't have any of that in evidence. But even if we did, the Virginia Code anticipates that this stuff happens, unfortunately, in that line of work. And that these people, they're not going to just get away with it. It's not okay. But the law anticipates that they will live to be prosecuted for these things. We talked a lot about this taser. We talked a lot about the different modes this taser goes into. We had a young man from the Department of Forensic Science who talked about how he downloaded his data and how he came up with his results. But even more interesting, the defense called an expert from Taser International, the company that makes this very taser that's in evidence. And he told us that drive-stun mode and probe mode are equally painful. And he told us that drive-stun mode is pure pain control. That's the last thing he told us when he was up on the stand. He told us he could tase me with probe mode. If I'm right here and he's where you are, he could tase me from probe mode. And he could lock up my muscles because that probe mode tase would override my central nervous system. That's what he said. He said that drive-stun mode is for pure pain compliance. This defendant disregards that. He says that he thinks that drives son is less painful. He disregarded what the defense's expert said. Let's go back to the beginning of his encounter with Mr. Chapman. He approaches Mr. Chapman and he says, I assume you know why I'm here. And he's telling us here today that that's a question. I assume you know why I'm here. And he has indicated on the stand today that that in his mind is a question. Common sense. What we know is that Mr. Chapman says on that video that you heard playing evidence is not just, you're not going to tase me, you're not going to fucking tase me. There's some things in between there. But the defendant didn't hear any of that. He indicated that he was the closest one to it. He wanted you to hear the truth from the closest person to it. But yet, he didn't hear any of that. And when the video was played here today, he still couldn't hear any of that. He still couldn't understand any of that. But what Mr. William Chapman said, you're not going to tase me when I didn't do anything to you. Those were likely some of the last words that he spoke. And that signifies he didn't know what was going on. I assume you know why I'm here. And the response that comes a few minutes later is that you're not going to take me when I didn't do that. This young man could have died without knowing why he was here. Use of a firearm in commission of a felony, in commission of murder. Clearly, this defendant used his firearm in the commission of this murder. He used his firearm because he made the decision that after whatever exchange happened between him and Mr. Chapman, that his next step in that use of force continuum was going to be this deadly force. We heard from several witnesses. We heard from Sandra Thomas, one of the Commonwealth's witnesses, who indicated that she saw pushing back and forth. Not deadly force. Pushing back and forth. She sees a few pushes back and forth. And after that last push, she said she thought the police officer was going to push him back, but instead he draws his gun like this. This is what Ms. Tynes demonstrated. She heard him saying something. Get on the ground. And next thing you know, Mr. Chapman is shot in the heart and in the face. And by the way, we've heard about this use of force continuum, and we've heard from the person that the defense had who came and testified, not as an expert, who indicated that center mass is not the face. We heard from Mr. Provo, who testified in great detail about what he saw, and he indicated he was right beside the defendant. The defendant doesn't know because he was in tunnel vision. Mr. Provo testified he was there to help. He testified he helps Portsmouth Police Department all the time. That's what he was there to do. He testified that Mr. Chapman took a jab step and came back. A jab step. No threat of death or serious bodily injury with a jab step and coming back. Common sense. Now we have several eyewitnesses from the defense. We have Paul Aiken. We have Stephen Price. We have Matthew Clearline. We have Albert Clearline. And they have varying recollections of what happened. They have varying recollections of where they were. They have varying recollections of what Mr. Chapman was doing. of what type of struggle ensued, of whether there were closed fists, of whether there were open fists, of whether there were elbows. But they all agree. You can see Mr. Chapman's hands from the length of a football field to a football field and a half away. And that there's no knife in his hands. There's no gun in his hands. There's no stick in his hands. There's nothing in Mr. William Chapman's hands. From this distance away, nothing in his hands. From Gregory Provost's distance, nothing in Mr. Chapman's hands. From Miss Sandra Tynes' distance, nothing in William Chapman's hands. But this defendant has gone into some kind of tunnel vision mode. And he's also testified that the hands are the deadliest thing. But in his tunnel vision between him and Mr. Chapman, he does not know what has happened with Mr. Chapman's hands, even though every other witness who has come before you knows that there is nothing in Mr. Chapman's hands. You saw pictures. You have them in evidence of this defendant immediately after this event. You've heard testimony from witnesses who saw this defendant immediately after he killed Mr. Chapman. You heard from the defendant about his condition immediately after he killed Mr. Chapman. Not a scar, not a bruise, not a mark. He told his fellow police officers that day who showed up, "I'm okay. He's okay." After he had shot Mr. Chapman in the face and heart. Varying accounts on whether he immediately starts performing CPR on Mr. Chapman. But he says that he starts doing CPR with his bare hands and that you can see all the blood. He also said he did not clean himself up. This is all the blood? Witnesses testified about the condition of his uniform, where the blood was. Mr. Wiggins said, this dot, the witnesses responded, yes. He immediately performed CPR. Why do we have two dots? Why do we have a dot here and there on this and that? This defendant indicated all the blood. That's all the blood. That's not a lot of blood. Common sense. Options. Let's talk about options. I approached this defendant today. We had an opportunity to talk about his radio. We had an opportunity to talk about this orange button. He referred to that as the end of the world button. He said, you don't hit that button unless it's the end of the world. Unfortunately for Mr. William Chapman, this was the end of his world. But it wasn't the end of his world. He has enough control over the situation that he can pull a cartridge out of a taser, throw it down to do drive stun on Mr. Chapman. But he doesn't have enough control over the situation to touch the radio on his chest and call for backup. Even if Mr. Chapman escapes, he lives to be charged with resisting arrest, maybe. Virginia law anticipates this. But this defendant made a decision not to exercise the option of pressing what he referred to as the end of the world button. OC spray, pepper spray. This defendant has said that at some point after this taser ends up on the ground, these parties back away from each other. And that's consistent with what some of the other witnesses have said, that they backed away from each other. But he chose not to use that OC spray, even though he had attempted to use the taser according to him, and he couldn't use the OC spray at that time because he was too close and it would be ineffective because it would get on his face. Now they backed away from each other. Option he chooses not to exercise. He doesn't carry his ass for him, that's his choice. Back to this use of force policy, this use of force policy that they have. Hard control technique. That's a step up from the taser. No hard control technique. But once again, nothing in Mr. Chapman's hand at best, with some of the witnesses who have changed testimony, who have seen fists, open hands, elbows, all kinds of other things, but yet no bruises, scratches, scars, marks, or anything on this defendant's face. Still, no hard control techniques were used. This man has done MMA, but he tells you that the MMA is not in the department policy, but he tells you that rather than do MMA, he draws his gun. Another option. He talked about pressure point, that you can hit on nerves. Another option. He chooses not to use it. All these options. And this defendant characterizes it that it's not an option because he decided not to. Just like at the beginning, when he walks up to Mr. Chapman and says, "I assume you know I'm here." That's not a statement, that's a question, because that's how he feels about it. Scene safety, staging methods. We talked to this defendant this morning about staging medics and about scene safety. In his mind, the scene is still not safe when he has shot Mr. Chapman in the face and the heart and has he's the only one who had his own gun, but yet the scene is still not safe in his mind. But Lieutenant Salsa testified that when he arrived, the scene appeared to be secure. No concerns for him. But yet, he's still concerned. He's still afraid. When he's the only one with the gun, this young man is laying on the ground, shot in the face and in the heart, handcuffed. He said he's doing CPR. And he's pumping his heart, and nobody's putting pressure on the wound. The medic testified that when the medics were performing CPR, one person had to hold pressure on the wound while another person pumped the heart, so that the blood would not be coming out of the wound while they were performing CPR. So if this defendant is performing CPR, he is effectively pumping the blood out of Mr. Chapman and everywhere. But yet, this is all the blood that is referred to. This is all the blood. Common sense. Mr. Chapman. Let's talk about Mr. Chapman. 18 years old, 5'8". Young man referred to by the medical examiner as skinny. Listening to music, approached by this defendant. I assume you know why I'm here. You ain't gonna tase me when I ain't do nothing to you. Mr. Chapman had nothing in his system that was detected by Amy Django from the Department of Forensic Science. No cocaine, no fentanyl, no methamphetamine, no methadone, no alcohol. Nothing, Mr. Chapman. You ain't gonna tase me when I didn't do nothing to you. Mr. Chapman, unfortunately, is not here with us to tell us what happened from his perspective as the other person who was close up on this incident. Mr. Provo is. Sandra Tynes is. All those other witnesses, however consistent their statements may have been, they were. This is what they all have in common. On a 5'8", skinny, 18-year-old young man. This is not a deadly weapon. Premeditation. Once again, you will receive instructions from the court on what all of these things mean, on what all of the elements that the Commonwealth has to prove, and I would say has proven to you all. What you may not know is that premeditation can be formed in an instant. The jury instruction says that premeditation need not exist for any given period of time. That means that under Virginia law, premeditation may be formed in an instant. And when did we hear about this incident with this defendant? Mr. Chapman didn't comply. Okay. So this defendant, instead of pressing the panic button, or as he calls it, the end of world button, instead of using OC spray, instead of looking over at Gregory Provo, instead of using hard techniques, hands-on, pressure points, MMA, anything, he decides that the next thing that's going to happen is going to be deadly force. He has drawn his weapon. And he has said, get on the ground, get on the ground. And because Mr. Chapman did not comply with him, according to him, he died. Because he did not comply and get on the ground, he died. The element of premeditation can be formed in an instant. When you have all these options, and you decide to say, because I didn't decide to, it's not an option. And when you do things like say, I assume you know why I'm here, is a question, because you want it to be a question. That doesn't make it so. Ladies and gentlemen, please remember the testimony from all of the witnesses that you heard, as I know you will. Please remember what you saw come into evidence, the pictures, all the physical evidence. And as you use everything that you remember, and as you look at the law, remember to use your common sense. Thank you.
May it please the court, counsel.
Thank
you, Your Honor. What do you expect them to do?
What did you expect him to do? Everything that he tried to do didn't work. Every step he took didn't work. Everything that Mr. Rankin tried to do to calm, diffuse, relieve the situation didn't work. All of us, that side, this side, everybody wishes that Officer Rankin could have applied Virginia code, whatever sections are that counsel referred to. That's exactly what he was trying to do. It's exactly what he was trying to do. Apply Virginia law. He wanted to arrest him for resisting arrest, but he didn't run. He wanted to arrest him for assault on a police officer, but he couldn't. He wanted to arrest him for disarming a police officer. Mr. Chapman wouldn't let him. He wanted to enforce Virginia law. His whole purpose of him being there. But he didn't have a choice. He didn't have an option. He didn't have anything else left to do. We all wish we would be here today. And the defendant that was sitting there was Mr. Chapman, and the witness that was testifying was Officer Rankin about an assault on a police officer. We all wish that we could be here today and be trying Mr. Chapman for resisting arrest, for disarming a police officer. And we would be. We would be. If he'd only listen. If he'd only comply. If he'd only said yes. Counsel talks about options. Options. Officer Rankin had options. Well, Mr. Chapman had options too. And every choice he took was a choice to escalate the situation. Every choice he took was a choice to make matters worse. Every choice he took was to inflame and rage himself and make matters worse. He had options. He exercised the wrong choice. Compare that to Officer Rankin. Each choice that he made was according to his manual, his training, his experience. Each choice that he made was pursuant to police policy and what they had been through in the academies and the military training. Each option that he chose was pursuant to the police officer's manual. The assistant chief of police came in to tell you that. Compare who made the right choice and compare who made the wrong choice. We are a nation of laws. We are a nation of the rule of law. We are a nation of law enforcement. We are a nation that depends upon law enforcement officers every day in our community to protect, preserve, and defend us. We rely upon them to keep the peace. We rely upon them to enforce the laws. We rely upon them to prevent lawlessness. What else did you want this man to do but to enforce the law? And it started off so simply. Such a simple law. Chocolate. Minor misdemeanor. It's all it was. Where would we be without law enforcement officers? Where would we be without them to protect us and to preserve our liberties? Where would we be? In a state of lawlessness and chaos. And all we had to do in this case was to say yes. You may dislike police officers. You may dislike what police officers want to do or what they say to you. But you know that the forum, the place, the time to challenge that is not by assaulting an officer, is not by disarming an officer, is not by striking an officer, is not by charging an officer. The time to do that is here, in court. In court. When you have a judge, when you have a jury, when you have a prosecutor, you have the time. That's the place to challenge things. If you've got disagreement, that's fine. This is America. First Amendment rights. Disagree. Protest. Do all you want to do. That's fine. But do it in the proper forum, in the proper place. Not on a parking lot at Wal-Mart where you're ripping off your backpack, throwing it to the ground to challenge this police officer. And we'll get to that in a minute. We are a nation of laws. And all Rankin tried to do was to enforce the law. And it would have been so simple. So simple. Counsel talks to you about how Mr. Rankin made these choices and made these decisions based upon things that weren't real, didn't show themselves appropriately, however you want to describe it. But you can't just take that one last incident. You can't just take that one last second. You can't just take that one last moment. You have to take the whole picture. And what's that picture? 1 minute. It's only 1 minute from start to finish. 1 minute. Lawyers talk about what we call facts beyond change. These are facts that are really not in dispute, that everybody agrees on. We may disagree with how far a person was, 100 yards, 150 yards. We may disagree about whether the light was red or the light was green. But there's certain facts in a case that everybody agrees on. Facts beyond change. Those are the facts that are going to guide you in your decision making. Those are the facts that you're going to apply to the law. Those are the facts that you're going to apply to the instructions that the court has given to you. And let's just review some facts that are really uncontested. It's the right suspect. Counsel seems to indicate to you in her closing that Officer Rankin had the wrong guy. That he went up to Chapman. Chapman said, I didn't really do anything, so therefore it's the wrong guy, so he should have just let him go. It's the right guy. Provo told us that. They met at the beginning of the Wal-Mart. He pointed him out. He told him what he looked like. He told him where he was walking, and he walked directly towards him, drove directly towards him. So when Officer Rankin approached Mr. Chapman, it was the right person. No ifs, ands, or buts about that. And we know also that Provo had called in a report of a shoplifting. So it's not as if Officer Rankin just stopped the guy willy-nilly for no particular reason, just because he felt like stopping him that particular day. He stopped him to investigate a criminal activity, a crime, part of his job as a law enforcement officer. It was a routine encounter. There was nothing unusual, nothing different about it. It was routine. He walked up to him and he spoke to him. Routine. They get to the police car. Everybody agrees Mr. Chapman is flailing at the police car. Flailing. Why? Under any circumstance. Why do you put your hands on an officer? Why do you push an officer? Why do you shove an officer? Why do you strike an officer? Why do you do any of those things? You got a brief, you've got an argument, you've got something you want to disagree with, you do it later. You don't do it then. You submit to what the officer's asking you to do, and then you argue about it later. There's no reason on earth for Mr. Chapman to have been fighting with Officer Rankin at that car. But we all agree that it does. The witnesses talk about it. Ms. Tynes talks about it. All the witnesses talk about the event that happens at the car. At the car, you heard Officer Rankin on that taser. Do you have Why did he take his hand out of his pocket? Why didn't he just done something simple? How easy that would have been to just take your hand. Why are you scuffling with an officer at the police car? Take your hand out of your pocket, give him your name, you walk away, end of the situation. But he didn't do that. That video shows the scuffle. That video shows the party interacting with each other, which never should happen. How many times did Rankin say, get your hands out of your pocket? It's a fact beyond change. Nobody disputes that. Taser. Counsel's exhibit number 5. You don't have all these pictures for your background. There's only one explanation. Struck. And that tells you the force that was used to strike that taser, because it disengaged the battery immediately. Why do you have that? Why did you do this? We agree the parties separated. They moved a distance apart from each other. All the witnesses talk about hands up, hands up, hands up. Mr. Chapman's hands are up. Even Mr. Provo talks about it being aggressive, in a fighting stance. And I'd submit to you that the evidence shows, you remember Mr. Aiken talked about how he thought that he was ripping his shirt off. Maybe it was Mr. Clearline. I'm sorry if it's my fault, I apologize, but you'll remember that. One of the witnesses from the Wal-Mart talked about him ripping his shirt off. Obviously, his shirt wasn't ripped off. But what did he rip off? Commerce Exhibit 3. He ripped off the backpack. He ripped off the backpack. Mr. Chapman, to throw it on the ground, to get ready to attack Officer Rankin. That's the only way that backpack got on the ground. And that's exactly the motion that that Wawa construction worker saw. He ripped off the backpack, threw it on the ground, and began to charge. Everybody agrees Mr. Chapman never obeyed one single command that Officer Rankin gave him. From the beginning, when he just wanted to ask him what his name was to get his information to turn over to Mr. Provo, to the next step when they got in the car when he told him to take out his pockets, to the next step after that when he told him to get on the ground, every command that he gave Mr. Chapman was disobeyed. Everybody agrees Mr. Chapman moved towards Rankin. Everybody agrees with that. From Provo to the Wawa worker, everybody agrees. There's some movement towards him. And after that movement, get on the ground, get on the ground, get on the ground. And it's only after those commands are given and disobeyed, only after the movement towards Rankin by Chapman, only after the throwing of the backpack on the ground, only after getting into that fighting stance, aggressively moving towards Rankin, are the shots fired. He may have said, shoot me, and that Rankin didn't shoot him. He may have said that a couple of times. Rankin didn't shoot him. The weapon was not discharged until the overt act of violence was displayed to Rankin. And that's all the evidence. Everybody agrees they moved towards him. We agree there's 2 shots that are fired. He didn't empty the whole gun. He didn't fire the magazine. He fired twice, which is consistent with all of the police training that they get. And it makes perfect sense. He didn't aim for his head. It makes perfect sense. First shot to the center mass, gun recoiled, boom, boom. Everybody talked about the second gun. It's tragic. It's horrible. It's sad. He had no choice. He goes to him. Rankin goes to him afterwards and he says, don't die, don't die, don't die. And you saw that in the video, and you heard that on the video. Counsel, I think, seemed to tell you this morning that maybe Mr. Rankin was making that up, knowing he was being videotaped. Go back and listen to that. He tells him, don't die, don't die. Provo tells us, breathe, breathe, breathe. The medics tell us he's there giving CPR. He's doing everything he possibly can to save a life that he never wanted to take to begin with. Because all he wanted to do was to stop it. Only to stop it. Chapman was 18. Does that mean that an 18-year-old is not capable of violence? Just because he's 18? Mr. Chapman had no alcohol or drugs in his system. Does that mean that a person that doesn't have any alcohol is incapable of violence? Of course not. Mr. Chapman had no weapon. Does that mean he's incapable of committing serious bodily harm or death against Officer Rankin? Of course not. Rankin had another weapon, a gun. A service revolver. And that's why he was in fear. He was fear of being attacked, being disarmed, and have something happen with that service revolver. How easy is it for all of us to sit here today, 15, 16 months later, to be able to sit here, very comfortable surroundings, nice chairs, air conditioning, peace, quiet, solitude. How easy is it for all of us to be here today and to look back on that one moment, that 1 minute, that 62 seconds of time, and to say, you should have done this, you should have done this, you should have done this. Were you there? Was I there? Was counsel there? We weren't there. But Officer Rankin was there. He got up that morning, or the night before, got dressed at his house, put his uniform on, put his duty belt on, and went out to protect, preserve, and defend, and to enforce the laws of the Commonwealth. He did not go out to shoot anybody. He did not go out to kill anybody. He did not go out to murder anybody. And so it's easy for all of us to be Monday morning quarterbacks. It's easy for us to all look in 20/20 hindsight and say, woulda, coulda, shoulda. But we can't. Because the law that's given to you by the judge tells you that each of you individually have to say, I have to view these circumstances from Officer Rankin's perspective, as the defendant, as what appeared to him, as what looked at him at the time. We have to do it. And we can't engage in this Monday morning quarterback and go backwards and hope and hope things will change. We've heard from the multiple witnesses that have testified. We've heard about the sizes of the individuals. The medical examiner's report, which has been introduced as Commonwealth's Exhibit 38. Mr. Chapman was 5'8", 187 pounds, muscular adult male. The decedent is seen to have an appearance older than the stated age. The medical examiner can call him skinny if she wants. I suggest to you that 5'8", 187 pounds isn't skinny. I suggest to you that an 18-year-old muscular man isn't weak. And you've already heard about how he overpowered Officer Rankin at the scene at the time that this happened. Each of the witnesses that have testified before you have done their best. Mr. Kroger, I'm sure, has done his best. Ms. Hines, I'm sure, has done her best. The four men from Wawa, I'm sure, have done their best. Each of them have told you what they observed and the circumstances under which they observed it. And I asked you to recall back last Wednesday during the voir dire. It was the time we were questioning you to make the determination about whether you would be as a juror sitting and so on and so forth. You remember Ms. Morales asking each of you, she said, can you accept that if different people saw the same crime, they might describe it differently based upon their vantage point, focus, or ability to recall and describe events? And that's just human nature. People see things differently. People view things differently from whatever perspective they may have. And that's true in this case as it is in every other case. But all of the witnesses agree. All of the witnesses agree that Mr. Chapman was violent, aggressive, disobedient, and moved towards the officer in an aggressive fashion. Everybody agrees to that. In fact, Mr. Provo, I submit to you, in one of his statements the Virginia State Police talked about how he lunged. Remember the state police officer came in and testified to that he lunged at the officer. He lunged at the officer. And it's interesting to note that counsel quarreled with the state police investigator, who was her witness the day before that, quarreled with the state police investigator about whether or not that was the accurate word or not. But they didn't seem to have any quarrel with the reports of the 4 Wawa individuals and the way the state police recited any of those facts or circumstances. We know the state police reported it the correct way. We know they wrote it down the right way. And we know that Mr. Provost told them that day, on the 22nd, he launched. All of the witnesses agree with that. Mr. Provost, interesting. You'll see the second video. We're not going to play it for you right now, but you'll be able to take that back with you and look at that. He comes in today, or yesterday, last week, and he testified about how he saw what happened, and he stood there, and he was in shock. And he comes in here today, and he talks about what he saw that day, and he talked about what Mr. Rankin did. But what did Mr. Provost say in that video? What did he do in that video? He's at the scene. Rankin is tending to Mr. Chapman, doing some sort of life support, CPR, checking vitals, however you want to take it, but some sort of resuscitative method. And he tells Chapman, and he tells Provost, stay around, you're my witness. And number one, why would you ask a man to stay around to be your witness if you've done something that's wrong? If you've been involved in wrongdoing, if you've used excessive force, if you've overreacted to the situation, why would you tell that man to stay around? But more importantly, what does Provo respond? Provo doesn't say, you're nuts, you just shot that guy. Why did you shoot that guy? He didn't do anything wrong to you. Why did you shoot him? You used excessive force when he wasn't doing anything to you. Provo didn't say anything like that. To the contrary, Provo said, I got you. I got you. I got you. What does that mean when Provo says, I got you? It means that he knows that Rankin did all he could to save himself. And he did all he could not to shoot. And he did all he could to protect himself. And Provo witnessed that. And that's why he said, I got you. The case, are we to assume that Mr. Rankin used the taser at the time solely to inflict pain, for pain's sake? Mr. Chapman, is that what the argument was? Does that make any sense whatsoever? Is that what they're trying to argue, that he used pain just to hurt him? No, he used pain to control him. He used pain from a compliance standpoint. And how would he have used the taser in the cartridge? How would he have used that? Just shot him right there, and then what would have happened? If his muscles had locked up like all the other, like the witnesses talked about, he would have fallen to the pavement. He would have hit his head on the pavement. That's not what they're trying to do. He's trying to control and diffuse the situation. That's all. That's the only reason he used that taser. And there's no reason whatsoever for that taser to have been knocked from him. None whatsoever. The court's given you a number of instructions. What you will not find in this instruction is that just because somebody has died, that a crime has been committed. It's an incredible, sad situation on all sides of this court, from every seat in this court, from every person in this court, that an 18-year-old lost his life. And that's incredibly sad. But just because someone died does not mean that a crime has been committed. And that's what the court's instructions will tell you. All of us, no matter, again, where we sit, have to feel for Ms. Chapman and her family. Of course. But your verdict is not based upon sympathy. Your verdict is not based upon compassion. Your verdict is not based upon any of the facts of that nature. Your verdict is based upon law and the evidence. And while we may feel, and while we may have sorrow, and while we may be sorry, that doesn't mean that a crime has been committed. The court's given you a number of instructions for you to be able to look at. Each of you are your own individual jurors. Each of you have to judge the case for yourself. You are in a unique position. Unique because you are the only people that have ever heard what really happened in the parking lot that day. And you are to judge this case based upon those facts, not some other facts from some other case, or some other circumstance, or some other event. You have to base your verdict on this case, on these facts, on what happened in that parking lot. And most importantly, you've taken an oath to be able to do that. You took an oath to Judge Morrison. You took an oath to counsel. You took an oath to me. But most importantly, you took an oath to yourselves individually to judge the case solely on the law and solely on this evidence as to what happened at this point in time. And that's why you were picked as jurors. You were picked as jurors because you're unique. You're picked as jurors because of the special skills as to who you are in your life, in your history and your characteristics, as to what brings you into this courtroom, and what makes you particularly suited for this case. And that's why we chose you, because we knew that you would follow it through. We knew you would follow the court's instructions, and we knew you would follow the evidence in this case only. And you are the first and only people to have ever heard all of the facts. Not rumors, not innuendos, not what happens at the barbershop, not what happens at Starbucks, not what happens at the 7-Eleven. What actually happens. A number of instructions the court's given you, certainly not going to read all of them to you, but they define to you the concept of self-defense. They define to you that the burden is upon the Commonwealth to prove beyond a reasonable doubt each and every element of the offense. The court's told you that if you believe the defendant reasonably feared, under the circumstances as they appeared to him, that he was in danger of being killed or in danger of great bodily harm, then the killing was in self-defense. And you shall find the defendant not guilty. Again, what's significant about that instruction of law is that you have to take yourselves, and you have to take yourselves from this spot in this jury room, and you have to take and transport yourselves back to April the 22nd of 2015 into that Wal-Mart parking lot and into the shoes of Officer Rankin as things appeared to him at the time. Again, not 20/20 hindsight, not Monday morning quarterback. Self-defense requires proof of a reasonable fear of death or bodily harm based upon an honest appraisal of the surrounding circumstances and an act by the victim which is taken by the defendant to signal the intent to inflict death or bodily harm, imminently and a proportional response by the defendant, and an act by the victim. Everyone agrees in this court that there was an act by Mr. Chapman towards Mr. Rankin. Everybody agrees. The law of self-defense is the law of necessity. It is not essential to the right of self-defense that danger should in fact exist. In other words, the fact that he didn't have a weapon after the fact doesn't matter. It is not essential to the right of self-defense that the danger should in fact exist. If it reasonably appears to a defendant that the danger exists, he has the right to defend against it to the same extent and under the same rules as would obtain in case the danger is real. So the fact that he didn't have a weapon doesn't mean that self-defense doesn't apply. The fact that he wasn't under the influence of alcohol doesn't mean that the defense of self-defense doesn't apply. The fact that he was 18 years of age doesn't mean that the defense of self-defense doesn't apply. A defendant may always act upon reasonable appearance of danger, and whether the danger is reasonably apparent is always to be determined from the viewpoint of the defendant at the time he acted. We're not talking about a bar fight. We're not talking about a card game that went bad. We're not talking about when somebody breaks out a pool cue or somebody gets drunk at a card game or something like that. We're talking about a police officer who's assaulted in the line of duty trying to enforce the laws of the Commonwealth. And under that perspective is how you must judge this case. The courts also instruct you This is instruction number 13. As Judge Morrison has already told you, all the instructions are full. Let me ask you to take particular importance to instruction number 13. In determining the reasonableness of the defendant's belief, you may consider, among other factors, these aren't my words. These aren't counsel's words. These are the court's words. You may consider, amongst other factors, the decedent's actions towards the defendant, the decedent's non-compliance with the defendant's commands, and the decedent's active resistance to arrest. Those are factors for you to determine. The law tells you as to how you judge self-defense. Again, Judge Morrison's told you it is not necessary that the risk of serious bodily harm be real, only that the defendant at the scene reasonably believed at the time of the incident that such risk existed. What else did you want to do? What else could he do? As he's being charged by Mr. Chapman, is he supposed to tackle him? Is he supposed to use kung fu on him? Is he supposed to use UFC fighting on him? Of course. Of course. If Mr. Chapman had just turned and walked away, Rankin told you, you would have just let him walk away, they would have called for backups, and they would have found him at a later point. But Chapman didn't walk away. He never walked away except at the beginning. Except at the beginning, every time after that. He never walked away, he always walked towards. He always walked towards. And that's the way that you have to view the evidence from the defendant's perspective. He didn't push the orange button. If he pushed the orange button, it would have been 3 minutes later before anybody showed up. Still would have been over. He didn't get on the radio. It would have been 3 minutes later before anybody showed up, and it still would have been over. Those things don't matter. They're irrelevant. Because it wouldn't have changed anything that happened. Because it happened in a minute. 60 seconds. Courts told you, when the Commonwealth relies upon circumstantial evidence, the circumstances proved to be consistent with guilt and inconsistent with innocence. It is not sufficient that the circumstances proved to create a suspicion of guilt, however strong, or even a probability of guilt. The evidence as a whole must exclude every reasonable theory of innocence. Is disarmed? Is attacked? Struck? Nobody, he won't listen to the officer's commands. He continues to fight. He takes off his backpack and throws it down. He puts his hands up in a fighting position, and he charges the officer. That, ladies and gentlemen, is a reasonable theory of innocence. It's not a reasonable theory of innocence. It's the evidence in the case. It's the only evidence in the case. The court again tells you, for the second time, suspicion or probability of guilt is not enough for a conviction. Reasonable doubt is based upon your sound judgment after a full and impartial consideration of all of the evidence in the case. These words are not just words. These words have meaning. These words have substance. These words have life. It's not a movie. You've heard reasonable doubt, burden of proof, presumption of innocence. It's not a book. You've read those things. It's life. These words have meaning. And we ask you to apply that meaning to this case, and the facts and circumstances of this case. Your verdict will bring closure. Your verdict will bring an end to this case. For the Chapman family, for the Rankin family, and for the community. And you are the substance of the community. You represent the whole of the community. And that's an awesome task that we're imparting to you. That's an awesome task that you have assumed by virtue of your decision to become a juror. And you're coming here to, as Judge Morrison has said so often, perform your civic duty. Your verdict has to be unanimous. All of you have to agree. And each of you represent the conscience of the community as to what happened. It As I told you, you're the first people to have ever heard all the case. You're the first people to have only have heard all the facts and all the circumstances. Not something that's happened someplace else, but in this court. And it's important for you to individually judge the case, but it's important for you to collectively judge the case as well. And you consider all of these facts, all of the evidence, all of the undisputed evidence as to what happened that fateful morning, April the 22nd, 2015. As a community, we must all say that Officer Rankin did all he could, that Officer Rankin had no choice, and this was Officer Rankin's last resort. And as a community, we must all say thank you.
Thank you. Mr. Broccoletti just said a whole lot. Said a whole lot of things. I like one of the things he said. He said that your verdict must be based on the facts, the law, and the evidence. Couldn't agree more. You heard the evidence. And just like the judge told you at the beginning of this case, opening statements were not evidence, closing statements are not evidence. That's a good thing. Because Mr. Broccoletti just brought a whole lot of things in that are not in evidence. You didn't hear anything in evidence about anybody ripping off a backpack. You heard witnesses talking about ripping off a shirt, ripping off a sweatshirt. And you saw in evidence, you saw that sweatshirt soaked in blood, indicating that William Chapman was wearing that sweatshirt at the time of his death. That these witnesses indicated that he had ripped off. Nothing came in about anyone ripping off a backpack. Nothing. Not in evidence. They don't get to create evidence and put things into evidence now that are not in evidence. Mr. Broccoletti indicated to you that everyone agreed that the victim's hands were flailing. Not in evidence. Everyone did not agree that the victim's hands were flailing. His own client didn't indicate that the victim's hands were flailing. What everybody agrees on is that there's nothing in Mr. Chapman's hands. Everyone agrees the taser was knocked out by, everybody doesn't agree with that. Everybody didn't come up here and say that. This defendant can't even tell you how that taser ended up on the ground. Common sense, once again. I've been shot. I've touched the door before. I've touched metal and been shot. And I jumped. I've never been tased. But I can imagine that if I was drive-stun tased in my back, that I would jump. Common sense. We don't know why Mr. Chapman possibly turned around, as some of the witnesses have described. But we have this defendant that testified that he chose to use pure pain compliance, and he chose to drive-stun tase Mr. Chapman in his back. We don't get to disregard what could have happened. Once again, we don't get to put things in evidence. Mr. Provo is here to speak for himself. He talked to you about what happened. Not only that, you get to hear that taser video where the defendant is talking to Gregory Provo, the Wal-Mart security. He says to Mr. Provo, "Don't leave." Mr. Provo is saying, "I got you." Okay. He's saying, "Don't leave. I need you as a witness. This is my second one." And that's when Mr. Provo is saying, "I got you." He's not responding to nothing. He's not walking up to this defendant while this is going on, and the defendant's not saying anything to him. He's just walking up to the defendant saying, "He did have him." That's what he did testify to. He did testify that he was right there ready to help, because he helps out Portsmouth Police Department officers all the time as Wal-Mart security. That's what he did say. That's what is in evidence. Once again, Mr. Broccoletti is concerned whether he was a suspect or not. He said, this is the guy. He said, we know Mr. Chapman is the guy because Provost said so. Well, does Mr. Chapman know he's the guy? This is alleged. He's an alleged shoplifter. I think the Portsmouth Police Department has the duty to walk up to people with some respect and ask them the question, do you know why I'm here? Now I assume you know why I'm here. Does Mr. Chapman know? Or is Mr. Chapman going on about his business listening to his music? We don't know. We'll never know because we didn't get to have Mr. Chapman come in here and get the opportunity to tell his side of things. We won't ever know. We won't ever know whether Mr. Chapman resisted arrest and whether he could have gone to court for that as opposed to being here for this. Mr. Chapman's on trial. This defendant is on trial, not Mr. Chapman. Doesn't matter whether I'm in a quarrel with a witness or not. That's who's on trial. Don't be distracted. The facts, the law, and the evidence. I like that. That's what this is about. And you've heard all the evidence. Charging, fighting. Once again, this whole thing about comply. And once again attributing to all the witnesses that they all agree that the victim in this case didn't comply. Okay. Charging. Not deadly. Pushing. Nobody's going to die from pushing. Mr. Broccoletti asked, when the victim starts charging, should he use an MMA move? Why not? Should he tackle him is what he said. Absolutely. As opposed to pulling out your gun and deciding that you are going to shoot somebody. Absolutely you should tackle them. He brought a knife. He brought a gun, excuse me, into what at worst was a fist fight. We have witnesses who have testified to pushing back and forth. We have witnesses who have testified to punching. We have the defendant who has testified he doesn't recall being struck. We have pictures of the defendant that show us there's no marks, no bruises, no scratch, no scrapes on him. But he brings a gun to what is at best for him a fist fight. The defense has conceded in its cross-examination, in its closing statement, that this victim was unarmed. They have conceded that he was unarmed. And they read jury instructions that the court had read to you. And I want to read one of them. I'm not going to keep reading it over and over again. You're going to have them with me. The amount of force used to defend oneself must not be excessive and must be reasonable in relation to the perceived threat. The use of deadly force is an act of necessity, and the necessity must be shown to exist, or there must be shown such reasonable apprehension of imminent danger by some overt act as to amount to the creation of necessity. The right to kill in self-defense begins when the necessity begins and ends when the necessity ends. And I want to remind you about something that Wal-Mart security Gregory Provost said. He talked about what happened when this defendant shot William Chapman. He said there was this jab move the victim bounced back. This is when the victim got shot by the defendant. And Gregory Provo was able to see a difference in his body movement in between these two shots. He said that after the first shot, he tensed up. Well, let's talk about necessity. It begins when it begins, and it ends when it ends. Now, I'm not saying I agree that it was necessary to use deadly force. I absolutely don't. Once again, you brought a gun into what is at worst a fist fight. But at the point where you shoot somebody, and if he's claiming he was charging at him, which Gregory Provo says he was not, why are you shooting him again? Common sense. I just want to say one last thing to you. We've gone over it over and over again. Over and over again. The defense has indicated, why didn't he just comply? Why didn't he just comply? This defendant is here to enforce Virginia law. Well, you have to follow Virginia law. Whether you are here to enforce Virginia law or not, you must follow Virginia law. No policy manual. No thoughts in your head about what you have decided was an option or not because you feel like it. Supersede Virginia law. You have to follow it. And because this victim did not comply, the defendant feels like he has to die. That's not the law. The law does not say that because you don't comply, you have to die. That's not what the law says. That's why the Virginia law anticipates that people can be charged with these crimes because they will live to be prosecuted for these crimes. Ladies and gentlemen, I submit to you, this defendant willfully and deliberately killed William Chapman with premeditation. He decided the next move he made to him, he was going to shoot him. He wasn't going to tackle him. He wasn't going to use MMA. He wasn't going to use pressure point. He wasn't going to OC spray him. He wasn't going to press the end of the world button. The next thing he decided he was going to do, he comes to him again, not complying, he's going to die. That's what he decided. And that was the end of Mr. William Chapman's world. That was the end of young William Chapman. I ask you to find him guilty of first-degree murder and use of a firearm and commission of that murder. Thank you.
All right, members of the jury, it's now time for you to first retire to the jury room. Your first order of business will be to select a foreman. Then you shall deliberate. Now, first thing, the defendant has two charges. Not to indicate what your verdict must be, but I cannot read them all at the same time, okay? As to the first-degree murder charge, after due deliberations, if you feel that the defendant is guilty of first-degree murder, the form read verdict, we the jury find the defendant guilty of first-degree murder. If, however, after due deliberations, with respect to the evidence and the law by way of the instructions, you feel that he is not guilty of first-degree murder, but guilty of second-degree murder, the form reads verdict, we the jury find the defendant not guilty of first-degree murder, but guilty of second-degree murder. You need not try to write this down because you will have your form with you, okay? If I ever have to do the deliberations, examining the evidence, recalling the testimony from the witness stand, and following the law, which is the instructions, you feel that he is not guilty of first-degree murder or second-degree murder, but guilty of voluntary manslaughter, then it reads verdict, we the jury find the defendant not guilty of first-degree murder or second-degree murder, but guilty of voluntary manslaughter. With respect to count one, as to the murder charge and voluntary manslaughter charge, if you feel that he is not guilty of all, then it reads verdict, we the jury find the defendant not guilty of first-degree murder, second-degree murder, or voluntary manslaughter. As to the use of the firearm, the same applies. If you feel that he is guilty of the use of the firearm, then it reads verdict, we the jury find the defendant guilty of use of a firearm while committing or attempting to commit murder. If you feel that he is not guilty, then the form reads verdict, we the jury find the defendant not guilty of use of a firearm while committing or attempting to commit murder. Number one, you select the foreman. Number two, you deliberate. If you have to arrive at a verdict, which must be unanimous, ring the buzzer and we'll come to get you. If you have any questions during the course of your deliberation, please indicate by ringing the buzzer. I will bring you out and will, if I can, answer your question. Notwithstanding what your question may be, I will probably know the answer. Because of rules of procedure, rules of evidence, and case law, I may not be able to give you an answer, okay? If that's the case, I will so advise. Now, as you can notice, members of the jury, there are 15 of you all, right? And in a felony case, there's only 12. But recognizing the fact that this case may take over 2 days, I decided to have 3 alternates, which means that I added 3 more jurors for the possibility that one of the regular jurors may get sick, an emergency may arise, or for some reason they cannot report. But that way, we did not have to start all over again. We'll have enough jurors. Now, juror number 13, 26, and 37. You know your numbers? I'm going to ask you to step out. You know your alternates. Okay? And I want you to stand by this deputy. All right? Now just stand in front of the jury box. All right? Step on 13, 26, and 37. Mm-hmm. Put your notes up there. Okay. You can't take notes on them, all right? You've been here since Wednesday. As I know for a fact from this vantage point, I can see everybody in the courtroom, and I can definitely see you. You all have been very attentive, you've been very patient, very accommodating. And on behalf of the circuit court for the city of Portsmouth, I truly want to take this time to thank you for your tremendous sacrifice. You've been on time, and again, you've been very attentive, been very patient. Your services are no longer needed for this trial. You are excused. However, please call the tape. I'm going to tell you the date. Call the tape, okay, at the appropriate time for further instructions. As you are escorted through this way by the deputy, you can give the deputies your badges and your numbers, okay? Have a good day. Mayor. Madam President, go back to the county instruction, we should have 12 instructions.
Yes.
I believe there's 21 with the addition of A.
20. Yeah, you played video during your closed argument. The part of the evidence,
Yes, sir, that was,
did she bring it back up?
we didn't use the clerks, we just used our,
Sure.
yes, sir.
Neither one of y'all have any evidence, right?
No, Your Honor.
No, sir.
All right. All rise.
You may be seated. Court is now